Welcome back, everyone. Now let's welcome our next speaker for session, Protecting Innovation Across Border, Navigating International Trademark and Copyright Law. For this, I would like to invite Kumsi Khanaro, Director of Khanaro and Kumalo Incorporated from South Africa.
Good afternoon, everyone. A lot has been said about AI and patents. I'm not a patent practitioner myself. I'm a trademark practitioner. I'm one of the directors of a very small firm in South Africa based in Johannesburg. I run it with my partner, Madoda Kumalo. And I've been invited to come and, share some thoughts about, what I think insofar as protecting innovation across borders is concerned, insofar as it relates to trademarks. I'm not going to say a lot about copyright law stuff. Previous speakers addressed that in more details earlier on. I mean, there's a lot that you would want to, consider and look into when you talk about protecting, your trademarks, especially across borders, and bearing in mind that, systems differ from one country to another, from one continent to another. There's a number of, multilateral agreements and or arrangements, if you may, that inform how best you can protect your trademarks. And you would have to obviously have, to consider the full cycle of your trademark life when you do that, ranging from assisting clients in selection of their trademarks up to issuance of registration certificates. And I mean, after that comes also maintenance, comes ADRs, dispute resolutions, comes quite a number of other things that you may have to consider as you do that, such as licensing as well. Something that I thought I should also, touch on that sort of links to trademarks, and not a lot of people talk about it a lot, is domain names that as you get instructions from clients, to deal with their portfolio of trademarks, you also have to have a look into domain names, which, it's a totally different system, if you may, that also looks at how you can also register that, linking back to the trademarks that you are filing for protection under. And I mean, also with domain names, you would have systems that differ. I know with the US, for instance, there's ICANN, which would be dealing with such namespaces as your .coms. And when you go to other countries, there's your top-level domains, country codes. For South Africa, it would be your .za. I know with Ireland, it's IE and such things. So you would have to also make sure that as you run your searches insofar as trademarks are concerned, you also do the same with your domain name searches. So as you prosecute for registration of the trademarks, you also do the same with the domain names. You also attend to their renewals. And if there's any dispute resolution you need to deal with, you also do that. The question then becomes, how do you then, in getting this off the ground and rolling it out, navigate, this protection internationally? And my sense is look, you really need to understand your client's business case, so you are able then to advise properly. You need to do some due diligence insofar as your client's business case is concerned, because I mean, at the end of the day, you'd have to sit down and decide, the classes that you would have to protect under in respect of the goods or services that your client is interested in, or they are already in that market providing those services or goods. You would need to understand the jurisdictions that are affected, that you'd want to have a look into when you protect such trademarks. You may even have to, have some relationships, be it locally, be it internationally, with other practitioners that are on the ground and that understand how the system works in respect of, respective jurisdictions. You need to understand how, internationally and locally, policies and laws and regulations of each and every country that you would want to protect and operate. We mentioned, well, not me, but there was mention earlier on by Jacob about the UK IPO office. These are again the sort of authorities that you would have to also understand as you do that when you focus in or on different jurisdictions. That for instance, if you are talking South African protection, then there is the commission, the Companies and Intellectual Property Commission, that you would have to file with. That's if you're not filing under, for instance, in Africa, let's say a repo, where there's an arrangement that if you file through that system, then you get protection in a number of countries. And essentially you would have to have a plan insofar as your implementation of that protection is concerned to the best that you are able to do so on behalf of your client. Generally, trademark rights are considered to be, distinct in each country and jurisdiction, and each country, depending on what their policies are and laws, they would want to recognize such rights insofar as they talk to their policies, and other considerations, perhaps social interventions and the like, and you would have arrangements where there are treaties that would allow you, in some instances, for you to file in one jurisdiction that also gives you protection in respect of other jurisdictions. So it really depends. And I mean, you would also have to have a look at how the system itself looks and how the system itself works, so you are able to then tap into those systems insofar as protect. I mean, for instance, we know with trademarks, just like any other international organizations, we have WIPO for intellectual property, which informs how the world systems work and how then we realize those objectives locally in respect of a number of countries. There are European Union trademark systems that, if you are focusing, for instance, in Europe, you would have to understand how that system works. If you are looking into going into Africa, you would have to understand how a repo works. I'm not sure with the US what systems we have. There's also the Madrid system. There's the Paris Convention, the Indian Pact. And I mean, importantly, these agreements here, the Nice and Vienna agreements, are also very important as you consider your client's business case and how best to protect their marks, logos, slogan, that you would have to have a look into, so that you are able to classify their business accordingly, and you don't, fall into misfilings. But generally, you can register anywhere, as long as your client is active in that space. You can register anywhere where your client looks to enter into, a particular market, and there are, arrangements, like I said earlier on, which would allow you to, maximize protection, only if you understand how they work. And I mean, where you're not sure, you are able to then, like I said, check with colleagues and consult and see how best you can then roll that out. Thank you.
So do we have any question from the audience side?
I have one. Just general question. You know how do you identify your country's law system? Is it belong to the group of civil law, or you say the U.S. law or the English law?
It's
continental, or just like Anglo-U.S. law, American law?
Look, we are mainly Roman Dutch in South Africa.
Yes.
And it depends again on the area that you are focusing on. Then it would differ from one system to another. For instance, I'm thinking now, our competition law, space, we follow more of the European system than we do the US system. But there are some learnings that we take from the US insofar as antitrust is concerned. When it comes to trademark law, I would assume we lean more towards the European, side of things, as opposed to the US. But be that as it may, we still apply these systems to the best of our abilities and to the extent it makes sense even for clients.
Yes. Well, my next question is actually related to our experience in China. Trademark is one thing. Meanwhile, you say we call the trade name, a company's name, also related to trademark. Sometimes, for example, some foreign companies, they come to China to do their business. And some Chinese companies or individuals just register that foreign company's name as a trademark in China. And then when the foreign companies found out that they want to have registered their trademark in China, they say, okay, you come too late because your name has been registered by some Chinese individuals as trademark in China. This is one situation. Sometimes they register a company using the similar, quite a famous trademark as a company's name. So based on Chinese law, I think in your country is the same. The trading name is also subject to certain legal protection. So that's sometimes cause the confusion, the trade name and the trademark. So have you met the same or similar situation in your country?
Yeah, I mean, with our system, they are interlinked. We have an organization or an institution called, the Companies and Intellectual Property Commission. So that's where companies and intellectual property matters are dealt with. Over and above that, we have, domain name authorities, where if, for instance, and again, it depends if you are, focusing on a company that's a startup that has never done anything, that's, looking into getting into a market, a particular market. As they register, they will have to register their company name. You will then have to advise them to also, protect, trademark their trademarks if there are any that are in existence. You would also, advise them to also register a domain name. So when you run a search, because most of the time you would have to run a search before you even go any further, before pumping money into something that you're not even sure if you will have rights over it in the future to say, we've run a search insofar as your trademark is concerned, proposed. We've run a search insofar as your company name is concerned. And this is what we are picking up. And as a result, we believe it's going to be a problem, or we don't think it's a problem. You can go ahead and file for protection. So it's highly unlikely, to find instances where, and I'm not saying it doesn't happen, where there is someone who is, owning a company that uses a particular name that is the same as a different somebody that's, that's owning a trademark that's similar to a company name that's sitting somewhere that doesn't belong to them. So it's highly unlikely to get into situations like that. But if it so happens, we have a system that sort of recognizes trademark, over and above what would be a company name. And again, questions of common law protection would have to be entertained about, use over time, who started using what, fair use, good faith, and all those considerations that would have to be made.
Yes. Any other questions from the audience? All right, thank you. So on behalf of IIPLA, we are happy to honor you. All right, now let's move to our next session, building an IP portfolio, strategies for startup and SMEs. For this, I would like to invite moderator Shashank Bhatia, managing partner of Tencom Intellectual Ventures from US. Joining him on the panel, Naveen from Logis IP LLP from India, Madhumita Datta from Lowenstein Taylor LLP from US, Denzel Abbey Cadet from Cadet Legal. I welcome you all.
Jeff Risha was supposed to be with us, but he couldn't make it. I have requested Dave Sankar to fill in for him, and he has graciously agreed.
So I welcome Dave Sankar on the stage as one of the co-panelists.
So, building an IP portfolio, strategies for startups and SMEs. I want to just briefly have each of you open with, your experience with structuring an IP portfolio, the importance of it for startups, the advantages of early development and filing. In other words, provisional versus non-provisional, core versus non-core, offensive versus defensive strategies. Then move on to maybe the path, the best path, which is product development, patent filing, funding, or if there's another order in which it goes. And then presenting IP strategies to investors, identifying core versus non-core patents, and licensing opportunities. I also want to delve into the common IP mistakes, especially that first-time filers of early startups make. I think there could be a lot of takeaways over there. And then leveraging IP for exit strategies, and also IP as a revenue stream. So let's start with, structuring an IP portfolio. Dave? Okay.
Hi. So as I said at the very first panel, I am not an IP attorney, but intellectual property is central to my practice. My background is advising asset managers or investment managers. And so central to what my clients do is identifying value, developing value, and protecting value. And so when you think about value and you think about the assets of a business, of course, there are various types of assets, but one of the big ones and one of the most important ones is intellectual property. And particularly when you think of the idea, when you think of value, and with startups, the valuation of a startup that has intellectual property that's protected versus a startup that does not have intellectual property that can be protected is night and day, right? I think I'd have to look for more recent numbers, but I know a 2023 PitchBook report found that angel stage startups with a patent, their valuations were up to 93% higher, and for late stage startups, their valuations were up to around 51% higher. And so, whatever your practice area is as an attorney, if you're working with businesses, and this isn't just startups, but we're working with businesses, you really want to advise them and be cognizant of what their value is, and that includes their IP portfolio. So I'd love to talk more about, kind of from my perspective, early steps that you take in structuring the business and looking at relationships between founders and early developers, and how those kind of flow into the work that some of my other colleagues do with intellectual property.
Hi, my name is Madhumita Datta. I am an IP attorney. So I guess, very tangible value of building an IP portfolio is so that people like us have a job. But why would somebody hire us to build an IP portfolio? I mean, being in Silicon Valley, we don't even have to convince anybody why they need to have an IP portfolio, kind of like what Denzel said, that your investors don't even believe in you if you're not serious about protecting your IP, because they don't want to take the risk of, they're investing money to develop a product, and then somebody else may not even have the product, but they have the IP on that. So, patent doesn't necessarily have to, I'm a patent attorney, so speaking mostly about from the patent perspective, but of course we talk about the other aspects of IP also. But if somebody has thought of that idea at some point and had the, foresight to protect that, that is enough to exclude somebody else from practicing the same IP. Even if the later player builds a product which is good, which has market demand, since they don't have the IP rights, they won't be able to probably be a prominent player in the field. So, and investors know that. So the first question they would ask, and not even savvy investors, even angel investors would ask you that, how serious are you about protecting your IP? A lot of the times, the founders would say, if we haven't raised funds yet, how can we hire an IP attorney and whatnot? But there are creative ways you can probably, you can do a first draft, file a provisional. I think we're getting into but at least, any savvy business person should have the idea that at some point, and not, hopefully not too late into the life cycle of the company, especially for smaller companies, you need to be serious about developing an IP portfolio.
Hi, my name is Naveen. I'm co-founder of Logisize IP from India. So I believe, IP portfolio, it depends. For the small companies, it can be a big financial decision to take at the very early stage. But once there's no particular order to have a product development, funding, and IP. But once you start, like I have an experience with my client, they started with one patent, and then down the line when they feel, okay, this is not a bulletproof patent that my product is, somebody can just come and do the incremental changes and then just go away with it. So in 3 years, we have around 15 patents around that single product, and right now, they have 6 to 7 infringement suits that are going I mean, that's just because we have this kind of portfolio that we build. So yeah, but if I say at this very
Infringement
beginning,
suits in India.
uh, yes, in India also, in UK, they have two suits going in UK. Uh, that's for a design patent and for an unregistered design. So you, in UK, it's very different than others. I mean, in India, if you register first, that's yours. In UK, you are the original. I mean, if you launch the product, there are inherent rights in unregistered design, maybe. So that becomes quite complicated because there is no trace. I mean, to trace that who launched the product first, and okay. So, but yeah, they and if you I mean, see right now the products are being developed in China, and then they are launching product in the US and UK market. So you find infringer quite often, and to tackle that, in UK, unregistered designs are, I mean, quite important. So I believe, yeah, we can start with the small, and then we can go with the help of continuation applications or with the help of PCTs. Yeah.
David?
Yes. So one of the things I've actually had some clients even wonder, well, actually, should I even invest in IP at an early stage? Because they say, well, why should I invest in this? Because, well, it's like I couldn't afford to, pay a litigator to enforce these rights anyway. So why do it? And I point out that it's like, well, you're probably not going to need to enforce your rights right away. You're building your rights now, and enforcement is something to be thinking about later. Later, you'll have more money. You may have been acquired by somebody else, and there's also, even more recently, litigation funding. So
Yeah.
there are ways to make that happen. So I first of all try to persuade people, yes, you really do want to invest in this early because it's valuable. And then, like Mahtomito was saying, was that there are ways to make it work. In particular, I mean, provisional applications is one way, as long as the provisional application has enough disclosure to be good. And that's important. But in addition to that, you've got some law firms that have creative solutions, like either deferred payment until a funding round, or some that'll even take equity for their work. So there are ways of making it work, as long as I mean, not all law firms are going to do that, but some that cater more toward the startups will do that. So there's ways to do that in a more cost-effective way.
Typically, if your IP group is more tightly integrated with your corporate group, a lot of the times, and that's the case in our firm, if the corporate group is bringing in a client, helping them with formation and seed round of funding, often they will take the equity or deferred payment. If it's an IP boutique, then you might not agree to do that on a deferred payment or equity. But typically for bigger law firms where the IP is seen as an integral service that you're providing to the early stage companies, a lot of law firms, at least in Silicon Valley, will, even before you have funding, because they're also helping you get the funding. They know if they secure the funding, part of that funding is going to come to hiring the IP attorney in the same firm. So it just makes sense. Yeah.
Which actually brings me to the third point instead of the second that I was going to address, and that is choosing the best path for IP strategy. Now, which of these would you recommend to a client or to a company that approaches you? Product development, then patent filing, then funding. Patent filing, product development, then funding. Or patent filing, funding, and then product development.
Just to kind of echo what you were saying, so I come from big law, but now I'm a solo practitioner with a single paralegal. And so I do M&A. I also do VC financings, and for deals that are bigger, I'm able to flex up by partnering with, like-minded, similar former big law escapees like me, who are willing to split the fee, and we tackle it. As part of that, though, I work with, I've said many times, I'm not an IP attorney. I work with, very talented patent and trademark attorneys, and we work similarly where. I'll bring in a client. Usually I bring in a client, but sometimes they do. And I work on a deferred fee. But part of it is I strongly encourage the client, and sometimes even, hey, I'm willing to defer, but pay your patent attorney now, which of course my colleagues love, right? They love when I do that. But really it's because strategically, what we just led with, like creating value. Let's go ahead and prioritize what is going to differentiate you and create value. And with the right partners, you can figure out how to get that order. But I agree with you that I think that that's the ideal order. It doesn't always work that way.
Okay. So for this, I believe there is no particular order. It depends on your business requirement. But as an IP attorney, I will choose first to do the patent filing and then go for funding. Maybe start with the provisional application, and then in next 12 months you can figure out the funding and the product development.
If I can share a real-world experience from my own career. Just to cut it to the chase, like I knew somebody, like a parent in my child's kindergarten class, the child's dad. He had a startup, very interesting idea, but didn't have any money for the longest time to file a patent or anything. Then at one point, I went to law school pretty late in my life. By that time, I had tons of experience as a patent agent. So they knew that I can do the patent work for them. But so they said, we just have this like little bit of money raised from friends and family, and we can pay you a little bit at this point. But not a lot, so we cannot afford you yet, but if you help us now, the moment we raise fund, we will hire you and pay your regular rates and all of that. But unfortunately, at that time, I was doing an internship at a federal judge's chamber, so I couldn't represent them. I was I had to sign that I won't represent any private company while I'm working for a federal judge. But I didn't want to lose that opportunity. So I told them that, why don't you guys just write up something? My secretary or my colleagues, who are not barred from representing you at this point. In 6 months, I'll be able to represent you. But there are ways to not lose that opportunity. So we didn't charge them a lot at that time, filed the patent, Then I kind of forgot. I thought I'm doing a favor to a person that I know. But 3 years later, they just called me and said, Mita, we got the funding and we can afford you now. So never lose an opportunity to represent somebody and give them the right advice that filing the patent is the right thing at this point. Don't lose this time window. So it really can come back to you in a very rewarding way. So my advice will always be patent filing, then funding, and then product development. So,
David?
I guess I'm going to be the outlier here, because in my experience, both funders as well as patent applications are going to require significant development beforehand. Because if you don't have the development done first, what are you going to file on, and what proof do you have in terms of getting funding? So I would say development is first, and then funding and patents. It's it just depends on whether you can persuade the potential funders or not. In many cases, it's probably worthwhile doing a patent filing, and then you can say, hey, yes, I've got patent pending. But I would say development, I would say, it would have to be first, because people want to. You don't want to file a patent application on something. It's what are you going to file on if you haven't done development?
The reason I asked that question is I wanted to share an experience of mine, and it's happened to me about 3 times in the last 7 odd years. I've traveled a lot between the US and India, and this is a Silicon Valley-based client where they had a fantastic idea. They pitched it to an investor. The investor said, what do you have to show? They said nothing besides the PowerPoint deck. Next, We filed 8 provisional applications. They got a valuation. They closed at about somewhere between $500,000 and $1 million of funding. And 3 years later, they were about into their 35th odd patent. They had a valuation of 30 mil, and they were still developing their product. Now that's one. The second experience is, especially in places like India, where a lot of entrepreneurs are very risk averse, and patenting is not high on the list of priorities. So what these guys are doing is they're developing a prototype, and I'm like, it's time to patent. They're like, but I'm not even sure my prototype works. I'm like, but you have the idea, you know? So by the time the prototype is developed, more often than not, it's too late. You've got tons of prior art that has entered that space. So that's one of the reasons I also advocate early filing. And by early filing, you know, early IP development and filing, I'll come to the next one, which is provisional versus non-provisional, core versus non-core, and offensive versus defensive. I'm opening it up. Yeah.
I can start. Provisional versus non-provisional is the easy one to answer. I wanted to talk about the core versus non-core.
Yeah, but let's hear your perspective on provisional versus non, because I have I'm opinionated on that as well.
Right. Yeah. No, I completely agree with David that just filing a provisional is not enough. You know, the provisional needs to have the comprehensive depth. Otherwise, you know, later somebody has to prove that your provisional didn't match well with the non-provisional. But still, if sometimes we file, it's called cover sheet provisional, you know, it's a very nicely written white paper, basically. And even big clients, you know, like institutional clients, not only smaller clients and medium-sized clients, they do that all the time. Their engineers are ready to file present the paper next day at a conference, and they're like, we don't have time to even write a set of claims because I don't even know what the technology is, and I don't want to just write junk claims. So we file provisionals a lot, but you know, by that time I'm reading the paper at least, and putting down my assessment as a patent attorney that it has enough technical depth. It's just not packaged in a patent type language. Even for those, you know, we do at least a round of reading thoroughly to see if the engineers are unnecessarily narrowing their scope. So a lot of the times I would just reframe the white paper into a patent type language, add a few boilerplate, you know, we all use boilerplates, you know. Change a couple of sentences to kind of leave the, you know, scope of the possible future claims broad enough so that they don't self-sabotage themselves. So I am a big proponent of provision, especially for the startups. You know, sometimes what happens is the inventors are the CTOs and CEOs of the company. They don't have time to work with you. They are just going to, you know, they just don't have time. They have bigger things to do. So for even from that perspective, filing a provisional makes a lot of sense because you just don't have availability for it, you know, of the inventors. And, you know, even if the provisional is very rudimentary, I mean, you kind of need a patent attorney to at least make it a little more broad than the actual write-up so that you can preserve your right later when you have more time. And so I do file provisional a lot, not for big companies that much because they have patent attorneys who are like, you know, managing this timeline of patent filing, but for smaller companies who don't have their internal patent attorneys and they rely on us, you know, we do, you know, advise them to file provisional if needed. Core versus non-core is an interesting, what is core, right? For a smaller company, you don't even know which way your product is going to do. You know, once you hire the right people, you know, that people, future hires might give you a direction of what is, you know, what can develop into a core product. So initially—
No, I'm not talking about core product. I'm talking of core patents versus non-core patents.
Okay.
How does one handle that?
So if you are budget strapped, then definitely, you cannot probably file a lot of non-core patents. But if you have budget, then it's worth protecting the non-core ideas also, because you never know which way your product is going to go. But if you're budget strapped, of course you might want to keep the non-core ideas as a trade secret for a time.
This is again anecdotal because it's my experience. What I thought very often while building a portfolio, our core patents turned out to be not so important.
Yeah.
And as the patent as it evolves through the patent prosecution process, you somehow discover that what you thought was a killer patent is actually not significant at all. And something that you thought was not worth the paper it was written on suddenly seems to be extremely valuable. I call this Rembrandts in the attic. You don't know. And this is the beauty and the challenge of the patent process, where it is very difficult to forecast what's going to be a patent that's going to be worth, multi-million dollars, or like 97% of patents that are written, not even worth the piece of paper it's written on. So that's what I meant when I said core versus non-core.
But it comes down to budget for smaller companies. It'll be very hard to convince the CEOs that file non-cores also.
For the provisional and non-provisionals, right now I had an incident with a client. So we suggested them, okay, you start with the provisional application, then you can go for the funding and etc. So he said, no, I want a real patent. Provisional application is just a piece of paper. My investor not even consider that. So now the people also wants that, okay, provisional application, anybody just go and apply. It's a placeholder, it's nothing more. So yeah, it depends, but your product development stage to have the.
If I could just add one kind of, again, contractual based perspective, but before, I think one just important thing in working with startups in particular, before you get to the question of are you going to do a provisional or a non-provisional, is you want to make sure that in all the contracts that you have with, whether it's founders, whether it's developers, we're talking about the idea stage, right? And we might not even know really what the core idea is, but you want to make sure that there are strong assignment of IP provisions, and it's a very basic thing, but you'd be surprised where, you have, for example, I have a client, it's a university team, it's a mixture of students and faculty from a university that is developing AI software to analyze images of the front of the eye, the anterior eye, for various eye conditions. Great idea. Part of when you decide whether or not to defer fees or not, is part of it is you do want to see, how much do you believe in the technology as the attorney. But one of the things that we ran into early before my patent colleague, Anu, could kind of get to his work is I wanted to know what type of agreements do you have in place and where did this idea originate? Because without those, strong assignment of IP provisions, when you finally decide on the core idea, what happens with startups often, right? I'm dealing with this with other clients where startup founders break up or people leave, and then who owns that original idea? So just as a step before, you want to think about those strong assignment of IP clauses.
Yeah, absolutely. I was just going to say founders agreement, about who owns the IP is very important. And that's when, working with your corporate colleagues help because they know that founders agreement need to be there, clear about IP ownership. So it does.
I was actually going to say, too, you said working students or faculty. It's also virtually always, if they're students and faculties, they're already going to have assignment agreements to the university. That's just the norm. So you might have a different problem there.
Exactly. Multiple issues even before you get there.
But one of the things with a lot of times with technology companies like some of us deal with, then a provisional really is useful in the context that she's just described, where I've had clients that literally say, okay, I've got this paper I'm going to submit to a conference tomorrow. It's like, okay, I better file a provisional on this.
Sure.
On the other hand, if you're familiar with in the big pharma context, they use provisionals because it gives them an extra year of life.
Of R&D, yeah.
Yeah, and
Yeah.
that's valuable because
very
that's-
valuable.
that extra year is at the end. That's the most valuable year yet. So there are some companies that use provisionals strategically from a money standpoint because it gives them longer. And I've also got a client now who's just like, well, this is just our norm to file provisionals. So, and the provisional and the utility application they're the same. It's just a matter of, okay, we're going to call it a provisional. So there's some people are doing that. So
If I may add just one thing, the other thing that sometimes it has worked, about convincing somebody to file a provisional is like, you get 1 year to decide whether you're going to keep it a trade secret, because at the end of 1 year, you don't have to file a non-provisional patent application if in that 1 year your business has pivoted. But if it hasn't, then there's nothing to lose. This is going to remain a secret document. Only, even there is no examiner assigned to a provisional. It's really a placeholder. There's nothing to lose, but probably, a couple of $1,000 given to an IP attorney. So it's worth filing provisional.
Yeah,
most of them.
a lot of my
Also in
colleagues-
India, you can convert the non-provisional to provisional in the meantime. Yeah.
Well, you can do that in the US as well.
Yeah.
Yeah, I mean, you file a non-provisional, and within a
then
12-month
decide,
period,
okay.
you can convert it if you feel that there's more work to be done. But how does how do each of you assess the value of your IP when your clients are presenting it to investors?
So this is a lot more up my alley.
Awesome.
So I think a few important things when thinking about talking to investors. As soon as you start talking about the subject of talking to investors, who we think of the SEC, right? And I think importantly, particularly with the wave of AI innovation and AI purported innovation, recent enforcement actions by the SEC and the FTC are really informative. And the basic principle here is, if your client is developing a technology, and in this case, since AI is very hot, AI, the big thing, whether it's the SEC or the FTC, is to avoid AI washing. And that's a phenomenon where, we've seen the way the market has gone for VC and startups in particular. People, after years and years of just money seemingly being thrown around, now we've seen down rounds, we've seen people having trouble getting exits, and the exception is AI and health tech for the most part. And so everyone, and Naveen and I were just talking about this at the table, everyone now wants to be an AI startup, whether they have AI or not. Well, that's fine, but if you're going to go to investors or to consumers and say that you offer a certain AI service or product, you want to make sure you're not AI washing, which means you are overselling or straight up inventing, aspects of AI or features or benefits of the AI. I'm talking about AI, but it could be other technologies that aren't actually there, because then you run the risk of violating securities law, like 10b-5 as far as misleading investors, or with the FTC, you're misleading consumers as to what you're actually offering. So what I would say is, whether you're a corporate attorney, whether you are a business owner, or whether you're an IP attorney, you want to work together and make sure that whatever you're saying to investors about your product or service, and including, we have something that's you can get a patent for versus something we can't get a patent for, because to an investor, yeah, that's valuable. Whether that's true or not can affect you dramatically and can lead to serious enforcement actions. There's been recent ones by the FTC, Do Not Pay, which was a robot lawyer that the FTC just brought an action against, where there was supposedly an AI lawyer that could do the same things that a regular attorney could do. Fortunately for us in the room, it could not. And the company got hundreds of thousands of dollars in fines. There are other recent examples, and again, the SEC also has been bringing enforcement actions. And the last thing I'll say is, just like all of us are really excited about AI in particular, the government is also excited about AI. It's the hot topic, so they're rushing to get their hands on regulating and kind of make their mark as well. So I would just say, consult with people who know, and then be very careful about the disclosures you make to investors and consumers.
This reminds me back in the day when e-commerce was the buzzword. You know, a lot of people doing work for Amway call themselves an e-commerce company.
I would just add that, not quite, like let's say you already have an investor and now you are pretty new, within the first 2-3 years of your life cycle, you have investors. So for each board meeting, I'm talking about a real life client, right? For each board meeting, they need to show the progress in IP. And for those small companies, if there is a quarter where I haven't gotten them a new patent, like what happened? Why are you slowing down? So I can see from their demands that it makes sense for them to convince their continuing investors that they're continually building their IP portfolio. And sometimes they said, oh, I said, okay, so in this quarter, something got allowed, but it hasn't been issued yet, so I cannot put them into the issued patent column, so your patent count will remain the same from last quarter. So they said, no, but the investors will want to see that something has been allowed. So we have to then, kind of in a bracket, like to be issued soon, something like that. So we can see the continuing importance of a growing patent portfolio from a, even a continuing investor's point of view.
No, the other question is that, have you seen the valuations change as the portfolio grows?
Honestly,
with
like we don't even do the monetization valuation, it's the perceived value. And for a patent attorney who is just building the portfolio, I think it's the counts, the number of patents that we're getting them attaches a perceived value. It's beyond my expertise to actually know how much monetization it is going to generate. For that, we would definitely need to have complementary professionals evaluating it.
Yeah. Definitely the number matters. I mean, you see somebody who's having 50 patents or 100 patents, it definitely attracts the investor also and the competitors. I mean, yeah, the number always, they want to see the number growing each time. Even if there is just a small changes, even the some of the client, now the AI and everywhere, they just want to add AI in their patent. They already have the allowed patent, but they want it with the AI. So yeah.
That could be self-sabotaging, actually.
Yeah.
David?
Yeah, I'm trying to think. So yeah, I've actually recently been speaking with a company that does actually evaluations because it's not something I've worked with before. So I'm going to be I'll be learning more about that. But one of the concerns I have is with just valuing a portfolio based strictly on count, because at least to a patent attorney, it's like there's a big difference between one patent versus another based upon the quality. So I personally am spending more time on quality, but I think that really depends on the investors, because some more sophisticated investors are actually going to look at the quality of the patent, but there's some who are not. So it's really going to be investor dependent, I think.
There are plenty of softwares now that tells you how good your patent is. It's AI generated. You can put your patent application number and then you can see, okay, how good it's rating.
Okay. You have to tell me after this. You have to
I'll
give me that too.
I'll tell you.
Which brings me to quality versus quantity.
Yeah.
Yeah. How meaningful threatening are patent filings and acquisitions to prevent copying and to create exposure for our competitors versus quantity, which communicates our IP value and readiness, including our level of IP sophistication and focus, how talented and inventive our engineers are, how well we allocate resources and our attention to value creation and protection. Before I ask you guys for comments, let me just share an anecdotal experience again. So we were filing prolifically for this one company. This is about 10 odd years ago. And I had never dealt with investors, and my senior was supposed to be at this meeting where the investor hired a lawyer, had their own lawyer, to basically grill us on the kind of patents that we had done, because we had filed too many too soon. And my quote-unquote boss, senior partner, whatever you want to call him, just chickened out at the last minute. And he just throws me into the, whirlpool. And I'm like, this is not what I've either, experienced with. I'm too junior and stuff like that. But I actually attended that meeting and I was grilled. And I had to go through every single patent, and they were almost 50 by then. And by the end of it, they valued us and closed at Series C somewhere between 40 and 50 mil. And they did not have a product that was making money yet. I have actually witnessed the value of intellectual property, causing growth in a company to be able to actually get to what they wanted to do. And that's why I asked the question of core versus non-core and, quality versus quantity. But yeah, go ahead. Back to my question, quality versus quantity.
Right. No, I had very similar experience as you. Like, the CEO told me that we have a board meeting coming up. They need to know what our patent coverage is. And at that time, that was a good project for me, little deviation from writing a patent rather than looking at what I have developed and kind of categorizing, similar patents in a bucket, then giving that bucket a name, and then brainstorming with the CTO, does that nomenclature that I'm coming up with describe your vision of the product? And so there we went back and forth with that. But basically I had to create the whole deck to be presented to the board. I didn't have to present it. By the time I worked with the CTO, he was conversant enough to present that work to the board. But yeah, the board basically, I kind of included what is the closest prior art we have found and how we have differentiated our claim versus what is already out there. So all these, I'm doing it completely from a technical, scientific point of view. Zero idea what the monetary valuation of it. But the more I'm convincing the CTO that this patent has value for your company, and the CTO is being able to convey that perceived value to the board, nobody even asking in millions, what is it? Is it 20 million or 30 million, So the value, I still approach my profession from a purely intellectual point of view without knowing what the price of the intellectual property asset that I'm creating. But I've been doing it for 18 years, and so it works. Even without being a monetization expert, you can create value for a company.
For a patent attorney, the value, the quantity and quality both becomes important. For a firm like us, we just started. We cannot give more emphasis on how, what the value of the patent. That depends on the size of the market, or that depends on the product sales. So if we have good novelty inventive step and industrial applicability obviously, so we can go ahead, but that depends on the applicant, that he can decide, okay, whether I'm going to make money with this or not. So yeah.
And what I'll say is, at the end of the day, although I maybe deal more directly with valuations and money than maybe some others in the room, I'm not the person who comes up with valuations. I will say that the way I've seen it done is very much investor driven, and that, like with any other aspect of valuing companies, a lot of times investors and valuation experts will use comps. So they'll look at other companies similarly situated with a patent, and obviously their patents are different, but as far as evaluating, they may look and compare, okay, well, this company had this type of patent, ours is similar in this way, different in this way, and then based on certain assumptions, they'll come up with a valuation. But a lot of times things are tied to comps, and at the end of the day, it is based on perceived value. So you don't need to come up with a number. It is just important to to try to create value as much as possible, and then there are ways that other people, that's their sole job, is to figure out how much things are worth.
Yeah. Yeah.
That's kind of how royalty is also decided, right? Similarly situated companies, sometimes not even in the same space, but in terms of the important score that somebody has assigned to the patent and all of that. So
Right.
very similar. The investors are very familiar with that there is some kind of framework that we can base on. So they're not too worried about knowing the exact value of the portfolio at this moment if they're convinced about the value of the portfolio.
No, it's not the value of the portfolio. What I'm trying to get at is, have you seen the value of the portfolio contribute to the valuation of the company?
All the time.
Yeah.
Yeah, there's
Yeah.
no other answer here.
Yeah. Which brings me to, do any of you have experience in witnessing the role of IP in mergers and acquisitions? Any experience, any stories to tell? Enhancing company valuation through IP assets, which is pretty much what we've just covered, and strategies for using IP as a smooth exit path.
Well, I don't have any knowledge about the second part, but just in terms of evaluation, yeah, it's particularly within technology companies in Silicon Valley. It's like your technology is frequently the most valuable asset. So I was involved in a deal some years ago where it was a $100 million deal, and it was based primarily on the patent assets that were being transferred from one a company to another. So yeah, it's definitely the IP portfolio is extremely valuable for the technology companies.
Right.
So, before I started my own, I was working for a company, and the CEO was working here in Silicon Valley. So he has 21 patents on VoIP, Voice over Internet Protocol. He sell it to Intel, 300 million nodes. So
Right.
yeah.
Yeah, that's very interesting.
Yeah.
Yeah.
And that's an Indian guy.
Right.
Yeah, so again, a big part of my practice, I do work with startups, but I also do a lot of work in the private equity space, which VC is technically a subcategory of private equity, but what I opened up with, the idea of value is it drives M&A.
Absolutely.
It drives the transaction. And I would say, a lot of the focus of the conference and panels has been patents, rightfully so, because a lot of what we're dealing with is tech focused and it's AI, but also the value of other types of IP play a huge role in M&A, right? When you think of M&A, you think about, and we talk about valuations, there's, the valuations are often based on various aspects, including the value of assets, the value, certain financial measures. A lot of my clients look at multiples of EBITDA, for example. But another valuable part of that valuation is goodwill, right? And goodwill is kind of the gap between where you can identify these are the financial or these are the value of the assets, and then what you're willing to pay, that multiple. That difference is goodwill, and a lot of the goodwill, not just for startups, but even for more established small businesses, is the brand and is the trademarks. And of course, a registered trademark is more valuable. And I'll give a very practical recent example where almost the entire value of the transaction was based on IP, and in this case, it was not a patent; it was a trademark. I recently just got a deal signed for the artist T-Pain. Some of you may be familiar. He's a Grammy-winning artist. He was really popular when I was in college, which is actually a long time ago. But I just formed a energy drink JV for him. So he brought his name, image, and likeness to the deal. We created a license to this JV entity that we created. He paired with an operator who had experience with beverage companies. And then really the value of the company was T-Pain's brand. And then we just signed a deal to sell that to a small public company. And the company hasn't produced any beverages yet, although we have deals in the work for distribution and development and all that stuff. But this was a deal where really the value was the IP. And so to your earlier point too, it does matter how strong the IP is, right? So I'm trying to build a brand with Cadet Legal, but if I were to sell to a firm, they're not going to say, oh, well, because it's Cadet Legal, that brand is worth a lot. Whereas someone like T-Pain, who's Grammys and internationally known and also has a huge video game following, which ties into the business strategy, it was the whole value of the transaction. So the IP is, again, it's about assets and value, and IP is usually a central asset, and it even factors into valuations. That goodwill is often an intangible thing that has a lot to do with trademarking.
Even if you see Under Armour, it's not about their patents, that their trademark, their logo, this U-shaped logo. So my trademark attorney was telling me that they filed around 180 lawsuits. Just if you file a similar logo with the USPTO, they're going to file the opposition, and that's trademarks is quite important.
So,
I just
yeah.
wanted to add that a lot of the times, people file patents only in a handful of countries, but when we're looking at the IP portfolio as a whole, and if that includes trademarks, like it's going to be so many countries all over the world. So the global perspective also is important. For example, one of my Silicon Valley startup clients really didn't want to file in China. They were very skeptical that, what is the level of protection I'm going to get there? But it's actually in the self-driving car industry, and we just got our first Chinese patents allowed, and then their whole perspective is now changing about the global valuation of their portfolio.
Right.
And, like it's the same client who wanted to see the allowed US patents in the issued column. They couldn't wait for it to actually issue. But good for me that in that quarter where we didn't get any US patent allowed, we got 2 international patents allowed. So now they are super happy that they can truthfully say that we have coverage of our technology globally. So it's an interesting perspective, and especially if you have a non-patent component into your IP portfolio, your global coverage view starts developing from early on.
Yes, I want to address your trademark and licensing thing, but before that, I don't want to miss this little bit of advice from all of you all, so I could learn from it. Common IP mistakes. Most common IP mistakes that startups, SMEs, since we are focusing on startups and SMEs, what are the most common IP mistakes they made?
So I have one that ties into trademarks, and also ties into our last speaker from South Africa, his great presentation and thinking about trademarks and also your domain name. I think a mistake that I see startups make is with their name choice. And it's such a simple thing. It's not technical. We're all really smart and we don't think about it. But sometimes that name really matters, right? And sometimes people pick a name just because they like it. And then they find out later on, just like I like to get my patent colleagues involved early on, I like to get my trademark colleagues involved early on to see if, what is the availability of this name. And when you think about the availability of the name, you need to think about, again, you think about value and growth of your business. You want to pick a name, not one that is, okay, yes, it's in this niche. It's okay to use it in this very niche, area where there's no risk of confusion. But if you have aspirations of growing, of expanding, of maybe moving into other verticals, right? You want to make sure that you pick a name that allows you the flexibility to grow. And oftentimes I see people either just pick a name because they like it, or they pick a name that it works, but it's very, very limited, and then they've pigeonholed themselves. And you've developed a great product. Now you're ready to move on to another product, and maybe even you're able to patent. But as far as the name, now you can't use that name for that new product or that new spinoff because you limited yourself. So I think that's a very common mistake. And again, this is early on when you're thinking about starting a company. The name does matter.
It does. So the second part of my question, actually, let me just say it before you answer, is that common IP mistakes is one thing, but second is how do you fix it?
you have to be a good negotiator also, you know. We are all technical background people, and we, at least in the beginning, you know, I went to law school much later. I had a thriving practice as a patent agent, and I had a very technical approach towards patent portfolio development. So, but after law school, probably after taking the contracts class and all of that, I'm super comfortable negotiating with my
Yes.
client that it makes sense for you to file it now. And kind of, you know, this is a small and medium-sized forum, but for my bigger companies, you know, where I'm mostly, you know, the in-house patent counsel has already decided that, you know, this idea is worth filing a patent, but when I'm actually interviewing the inventor, they would open up saying that, no, this is like such a known idea that, you know, it's not worth filing a patent. So you then have to kind of convince them, the engineers, that no, to you it's like a incremental value and you are not proud of the little addition that you have made to an already existing, but for the company, it makes sense, you know. So you kind of, it's not quite fixing a mistake, but almost avoiding the mistake of not filing a patent on an incremental idea. So, so the mistake would be to, you know, be convinced by the engineer and not file the patent. So as a patent attorney, your duty is to convince them
Right.
of the value of protecting the idea.
Right, no, but from a patent perspective, you know, the common IP mistakes that I have seen is public disclosure before filing,
Of course,
failure in due diligence, not adequate FTO. And that is what I'm asking, is how do we fix mistakes like these?
Yeah, so about the FTO and, you know, I think, again, smaller companies and bigger companies have completely different approach in terms of whether they do patent search, a landscape search.
Yeah,
before
smaller is
filing.
rogue, guerrilla, you know,
I
it's
guess.
just quick and dirty, you know, absolutely.
But, you know, that's why all the time, I actually do landscape studies and freedom to operate or patentability analysis for the smaller companies, because I want to minimize the risk of spending all the time and money in, you know, filing a patent and then discovering somebody else has already done that. But the bigger companies always take a position that go blind, file the patent, assuming no prior art exists. If the patent examiner, the burden is on the patent examiner to find
This
that.
is the most interesting contrast in our experiences,
Yeah.
because the go blind experience I have is with the smaller companies.
Oh my God. Then, so there's multiple ways of getting to the same result, I
Yes.
guess. But yeah, for me, it's almost black and white. For the smaller companies, we most of the time do a search before filing a patent, because, you know, that also is built into their IP budget to conduct a search. And
Sure.
sometimes we engage third parties to conduct the, you know, more comprehensive search for us. But for the bigger companies, it's almost a mandate from their in-house counsels, never do search. Because if you do search, you have to file the
Then
information.
you have you have to file the, then
a
you have an
duty of
obligation to
disclosure,
submit the
right,
IDF.
Yeah.
Right.
So.
For the trademarks, I believe the common mistakes they do, it's how they going to use the trademark. I mean, the word and the logo. And initially they file it, okay, just file the word mark, just file the logo this way. And then they start using it differently. And then when you submit the statement of use, it's like, it's a bigger problem if it doesn't match. And patents, I believe the FTO and the patentability. So understanding that, okay, I have the patent, that means I'm not going to infringe anybody. So they did quite some time. I mean, once, like, okay, if my product is patent eligible, that obviously means I'm not going to infringe anybody. But that's not true. So yeah.
David?
Yeah, I mean, there's lots of mistakes that are of various sorts. The one that comes to mind, the biggest one that I've seen was that I was involved in a deal where the company that I was representing was buying a pretty good size portfolio of patents and applications from a much larger company, and so. And you know, and they paid a very large sum of money for this. But even I was a junior associate at the time, and even to me, I could tell it's like I don't think it's worth anywhere near that amount. And as we learned later, it was like this much bigger company was not making money out of this. They wanted to unload it. They would have been willing to give away for dramatically less than what was paid for it. So they probably paid 2 or 3 times, and I said, that's enough money to pay for my patent prosecution services for my lifetime. And it's so much money that they spent that they didn't need to. And the only question I have is could they have discovered that? And I think they could have, just by spending a little more time doing some due diligence in terms of, well, why is this big company wanting to offload this portfolio? And then they should have done that. I mean, it was a big loss of money.
Sure. Which brings me to the final part before I open it up, which is, licensing or selling patents and creating an independent revenue from IP assets. Trademarks we know, but I'm talking about hard IP like patents. Recognizing that the life of a patent is actually quite independent of the life of the product. Therefore, and that's what I meant when I started by core and non-core. What is a core patent today as your product evolves may become a non-core patent tomorrow. And when it becomes a non-core patent, it could be reading upon multiple products in multiple verticals that are potentially monetizable. And this is where the IP awareness amongst startups and SMEs is not there. Unlike the IBMs of the world, who actually have billions of dollars in licensing revenue purely from patents, not products, and they make a distinction between licensing from patents, licensing from know-how, and licensing of software, and selling their products. So the elephant in the room is non-practicing entities. Because what then is the difference between licensing a patent of a legitimate company that has a product portfolio and licensing of a portfolio by a non-practicing entity? Any thoughts?
Haven't dealt with developing a portfolio for a non-practicing entity. So, but I was aware in my first, when I first started in this field, Intellectual Ventures was a big client of the the boutique firm where I started my career. And of course, their devotion to developing the patent portfolio was a dream for a patent attorney, right? They would actually, so I guess for the boutique patent attorneys, I don't know what exactly the question is here.
I'll frame it differently since you mentioned Intellectual
Yeah,
Ventures.
yeah.
My question is, when you're writing a patent application,
Right.
how would it be any different writing the application for someone who's a non-practicing entity
Yeah.
vis-a-vis writing the application for someone who's a practicing entity?
Technically,
The approach
they
would be the
should.
same.
Exactly.
You know?
Yeah, I was going to say that.
So the
The
value
approach would
derived
be
from the patent,
exactly.
the value
Right.
derived from the patent can
Yeah.
be multiple.
Yeah.
It could be through a product,
Yeah.
and it could be through the patent itself. Because when a
Absolutely.
company that has a product portfolio is offloading, like Dave
Right.
said,
Right.
their patent portfolio, they are offloading not their products,
Yeah.
they're offloading their patents. So any opinions, thoughts on that? Let me open it up if anybody's got any opinions on licensing, monetization. There are ethical issues that have been raised on this over the years. The word troll has been used derogatively. Vishal.
See, you exactly hit it on the head, because there are two aspects to non-practicing entities. Yes, there are entities, and some very big ones, Intellectual Ventures being one of them, that are basically monetizing patents, but there's a flip side to it. And in fact, it's very important today because patent litigation funding is pretty much a very big deal. It has grown by a factor of 10 in the last 8 or 9 years alone, between 2018 and 2017, 2018 to today. And there's a reason for that. One is the flush availability of funding and people recognizing that. But the other flip side is that there's nobody really fighting for the small guy. whether it's a small company or an
Right.
independent inventor. And so the only way, unfortunately or fortunately in the legal system today, is that if you go in good faith negotiations, I mean, you are just a fly, you are swatted away. So your
Sure.
only way to get attention is to actually file a lawsuit, for specifically for patent, hard assets.
Right.
So therefore, if there is in fact a genuine class of investors or small companies that for whatever reason have good intellectual property and it's being violated left, right and center, they have no recourse. So the non-practicing entity in the form of funded by litigation investors is a venue for that kind of inventor to get value for what they've done, whether it's a company or an individual investor. And there are non-practicing entities that are doing that. And so
They will aggregate patents from multiple small inventors and take on the big guys? Is that what you're saying?
Not only that, they may even just do it with a small patent portfolio of a small inventor. I've seen
Sure.
2 or 3 such examples where they had some inventions in, let's say, PON, packet optical networks, passive packet optical networks, and there were 2 brothers who had filed over the years 13 or 14 patents in 2 or 3 different areas of operating, and they couldn't make the company work. So the company was gone, 10 years ago.
Right.
But they had eventually to make a non-practicing, like a specific firm that was assigned the rights to the patents, and then the patents could be prosecuted against. So many people are using PONs, hotels are using PONs, different kinds of verticals are using packet optical networks, a lot of which could have applied, their patents could have applied to that, but they had no recourse until they did that. So they had in their filings, in their complaint, they would write that we went to these negotiating, we tried negotiating with ABC and we had all these meetings over many months and nothing came of it. So my point is that non-practicing entities are not always to be maligned. They are playing a
Absolutely.
very critical role.
Absolutely.
And clearly the
Totally
market
agree.
thinks so. Because otherwise the litigation funders wouldn't be funding those.
Not just
those
that.
entities.
I brought this up but, because I actually agree with you. And I've been hearing a lot of negative publicity and feedback and comments and opinions on these non-practicing entities. And the point I constantly try to make is they actually are the insurance for the small guy who's started a company, built a bunch of patents, spent through his or her nose, and the company's not done well. At least there is an avenue for someone to monetize those patents, and sometimes they can be huge.
Exactly. There's a billion reasons why a company or startup could fail, and that may have nothing to do with the quality of their technology.
Absolutely.
And that's more true today than before, because we are going to see a lot of, we've always had, 90% of
Yes.
startups fail. But there are many more startups in many more verticals, and we've been talking the whole day about the value chain of AI.
Yes.
And there are hundreds of opportunities to write a very interesting and brilliant ideas that may not all go to market. But that doesn't mean some big guy is not going to capitalize on it.
Absolutely. Thank you, Vishal. Anyone?
Oh, okay. Thank you. Shashank, you said something earlier on about the IP mistakes that we commit as practitioners, and I want to jump in on the the trademark law side of things.
Sure.
For me, I've seen 3 main mistakes that we would commit. One being to rushing to filing without having conducted a search. It's always best to suss out what's going on there, and you get an international, search that gives you results in respect services or goods that your client is interested in.
You're discussing trademarks specifically.
Specifically
Right,
trademarks,
right.
yes. Because when you sometimes when you just rush under pressure to file because of pressure from client, is that then when the mark is prosecuted, things that come up that could have been avoided had you run a search and you prepared an opinion to client saying I think there might be problems, maybe rethink your trademark or your trademark protection. The other one that's common is when even the mark or a proposed mark, then you take it as it is from client, and you file it in respect of the goods and services that client is interested in, but you don't break it down for them properly as you would. I know sometimes it attracts extra cost, legal costs for clients, but sometimes you take it composite as it is and you just file the protection. You don't break it down to say there's a logo, there's a trade name, there's a slogan, and then tomorrow they want to use it, broken down into parts, when you could have done it, for them in the way that you protect it, as a whole, and then you also break it down, focus on the logo, into the relevant classes. That's also a big mistake, and sometimes, you can't correct it later.
Sure.
The other one would be, misunderstanding their business case. Because if you don't understand their case, and sometimes you just have you hold a consultation with them, it's a verbal thing, and they don't give you a business plan, they don't give you, strategic documents that talk to their business. Because then you are able to also pick up from what their business case is, what the relevant classes would be that you need to protect under. So, insofar as treatment is concerned, for me, those are the big, problems that we could.
Thank you. So,
If you'll permit me just two unrelated comments.
Sure.
One, as to non-practicing entities, I always like to point out that they're not always patent trolls or some very legitimate, well-respected institutions. My favorite is always, we've done work for universities and their tech transfer offices. Universities never practice it, but they're very responsible, for a lot of technology that gets developed. So just wanted to point that out. On the trademark issue, the issue about the thing that goes wrong, and this is not inadvertent, I think they get different advice. Companies, the marketing component, or whoever they talk to about marketing, always wants to give them a very descriptive or generic name. If you're starting a hotel, the marketing people say, call it the hotel, which you can't protect. And it's not only a mistake, it's usually an involved discussion, sometimes a negotiation with the marketing people who want to have it be as descriptive as possible, and the trademark lawyers who want to have something that's protectable. So I don't know if you've
Right.
had experience with that, but I've seen that a lot.
thank you.
We have
We've got
Follow-up comment
yeah.
on what Ira said about the universities, right? I mean, we've been talking the whole day about biotech.
Yeah.
I mean, the CRISPR patents, right? I mean,
Yeah.
there was a battle between, Berkeley and MIT. MIT got the patents.
Absolutely.
But they are not really the ones going to be practicing it. The entire biotech industry is going to practice it.
Absolutely.
And they're going to be getting the revenue. That was what the battle was about.
Yeah.
So you have a non-practicing entity right there.
Thank you.
we have one question.
Thank you. So I guess two comments, one of them following up on the question about M&A. My day job is to do buy-side diligence and sell-side due diligence on tech-rich companies in the context of M&A. And certainly we see a lot of value that could be added when companies have good IP portfolios. The question is, people don't really understand what good looks like, right? You talk to people outside of this room who are not IP professionals and you ask them about IP, and if they can spell IP, that's already a good start. And so, what my practice aspires to do is when we are working with companies that are looking to raise capital, we're really trying to help them articulate what is good about their IP. And that often starts with just explaining to investors what's the asset, right? Patents, trade secrets, software, trademarks, and what's in each one of those. And that's really the very basis of it. It takes a lot of explaining to investors to go through them step by step what is good IP. And going deeper into that, you start thinking about what does it cover in terms of technology. Does it cover the technology that's used in the product, or is it something that's completely different, right? That's an important aspect to know. Jurisdiction is yet another area that people really need to think about in terms of just understanding coverage of the IP portfolio relative to where the business operates in terms of sales, marketing, R&D. And then investors love comps. And so tell us about other portfolios that are out there. How good is it relative to everything else that is operating in this space? And it's only when you paint that picture for the company, on behalf of, their investment bank, that, the people who are looking to raise capital for them can tell that story for them. So On the sell side, we work with the company, understand the assets, work with the investment bank, try to align on what the investment thesis is, and let them go to market with a story about the IP and the company that is really, really aligned. That's where we see true value creation from an IP portfolio outside of like a licensing IP valuation context. The other part that I wanted to respond to was about licensing versus just focus on the core. And then my answer would be more specific to startup companies and early stage companies in particular. I think for companies that are at this stage, it really is about focusing on the core. You think about where they are today versus where the market that they're looking to enter is, right? The technologies are not mature. People don't really understand, who's going to be the winner here. And so the IP truly is only going to support the enterprise for the next 3, 5, 7 years. As things become more mature and people sort of know what technologies are adopted, patents and claims become, a little bit more standardized in terms of understanding what's practices. That's when you can really think about licensing and monetization. But I think even for founders, licensing and monetization, for the most part, is not going to be plan A for them, right? There might be exceptions to that. If you have a semiconductor manufacturing process, you're probably going to license that because you're not going to build your own fab, in which case you're looking at building a very different portfolio than what maybe a consumer technology company would be looking for.
Right, thank you. The point I was essentially trying to make was that there is, I agree, focus on the core, but the fact is that when a patent portfolio is built at the very onset, there is value or potential value that can be derived from these patents that does not hurt the core interest of these startup and these companies that are just getting off the ground.
Yeah, I agree. And I think that's like good patent attorneys will think about that.
Yeah.
And include that in the specification.
Yeah.
So just a comment here, what our experience says while working with these non-standard, non-practicing entities like intellectual venture, they wouldn't invest in drafting the patents. So what they do is typically they look for a portfolio related to the big companies, and they ask the searchers, companies like us, to identify small corporates or small inventors who can, where they have been infringing upon. So this is the kind of practice they have been following. So that's probably the reason that their reputation is not that good. So they do not have any inclination to support small companies. Their inclination is to make money.
What you're suggesting is that companies like intellectual ventures, they are acquiring patents
Correct.
from smaller companies or inventors, and they're enforcing it against the big guys.
Correct.
Is that correct?
Yeah.
Yeah, okay. I think we are out of time.
Yes,
If there are,
I have to say,
okay.
I personally didn't work on, that intellectual ventures portfolio, but my colleagues were writing patents on original ideas for intellectual ventures. So from a patent attorney's perspective, it was no different than whether they were making a product or not.
That's been my experience as well. They do both.
They do both.
Yeah, they are building portfolios of patents on their own, and they're acquiring patents, and they're consolidating in order to be able to derive value out of it. I think, anybody else, any more questions?
Any other question from the audience? Yes, we have one. 2 also.
Just a very quick comment in terms of the talk around licensing and the impact that then has on valuation. Often if a company is going to start licensing, they put the contract in place, the revenue's coming in, they sit back and think, great, I've done that, I've ticked that box. It is so important to be actively monitoring that. It's a trust-based relationship normally. It's self-declaration by those licensees, but so often revenue is leaking from that relationship, and that then has an impact on the future valuation. Denzel mentioned EBITDA, and a multiple being applied to that is one of the very common valuation methods. If you have $500,000 leaking from that relationship, and you are a fintech firm, 10 times multiples normal for that, well, that's 5 million that's leaking from that valuation. Suddenly that starts to add up, and that has a big impact on the money you're going to make from that organization.
Yeah. Thank you.
One last comment. You asked somewhere about evaluation of the value of these assets. So I just want to put a data point. There's something called Ocean Tomo's intangible asset market value study. And back in 2015, they found that 68% of the S&P 500 listed companies, their valuation actually comes from what they call intangible assets, which includes patents, trademarks, copyrights, etc., and goodwill. And in 2020, that number had moved, well, according to Ocean Tomo, because they're in the business, 90%. So 90% of the S&P 500, according to their study,
Their valuation
is
from
really
intangible
coming
assets.
from intangible assets.
Right.
Today. So that already gives us a sense of
an
how
interesting fact that now this is from memory, so you can fact check this and catch me if I'm wrong. In 1970, about 70 to 75% of the valuation of these S&P companies was plant, machinery, and tangible
Exactly.
assets.
You're absolutely right. Yes.
And that number has flipped today.
Yes.
And this is flipped in the developing world. So if you look in the developed world, so if you look at the developing world today, the most valuable companies are still valued based on their plant and machinery. And if this is any indicator of which direction the world is going, we can't possibly overestimate the value of intellectual property.
Sure.
If I may just add something, intellectual property is one form of intangible assets. There are other forms of intangible assets. One of them is data, basically the data that you own. And raw data is not protectable under intellectual property because it's a fact, but the way you manipulate that data or structure them into something meaningful, that can be covered by intellectual property also. So the definition of what is intangible asset, it doesn't only map with intellectual property. So, I think we, the intellectual property attorneys, have started to see values in filing intellectual property based on just data. Whether we will get those patents or not is another question, but at least we're advising people. One of you were talking about what mistakes to avoid. One mistake to avoid is don't underestimate the value you can generate from the data that you own.
Another mistake to avoid is we are way ahead of time. You want to get thrown out of here, or you want to voluntarily get off stage?
I'm going to say just one thing quickly about the data is almost in all cases, the data should be protected as a trade secret. So it's still intellectual property, but we protect it as a trade secret, which includes your raw training data for an AI model, the AI model itself, and anything related to that. Protect that data as a trade secret.
Thanks, Dave.
All right. Thank you. Let's give our panelists a big hand. Now I request a moderator to present a memento to our speaker. And we can, that's it. So we can have a group photo for this session. Madhumita, we'll have a group photo for this session. Thank you once again.